Okay, good morning, everybody. Welcome to the next and latest session in our series of webinar Wednesdays at TAROE Trust. My name is Darren Hartley. I'm Chief Executive here at TAROE Trust. And today we're going to be focusing and receiving a presentation from two representatives, Dave Simmons and John Goodwin from the Housing Ombudsman Service. We've had a good degree of interest in this session. A couple of housekeeping things first. I mentioned earlier, everybody's been placed onto mute just in terms of so that it's no interference to when the presentation is being delivered. But there is a chat function if you want to chat as we go through, and there will also be the option for opportunities as Dave and John run through the presentation to ask questions, to pause, and if you want to come in and ask them verbally as well, that's absolutely fine. So I'm told that there will be natural breaks as they work through the presentation for that to happen as well. I'll try my best as well to monitor the chat function and respond as we go through, because it's a little bit difficult when you're delivering the presentation also. Before I hand over to Dave and John, there was just a couple of other information items that I was going to relay to you today. The first one follows on from our last webinar in relation to our manifesto for change. We've now got a revised draft manifesto, which is on our website. It's on the front page of the website. So if anybody, it's going to be open for about another 4 weeks or so, the consultation period. So if anybody did have any feedback for us on that manifesto, they're most welcome. We want to make sure that we've got that correct, and that it's well aligned. Obviously, the people have differing views, and we've had to kind of try and navigate a path through that. But hopefully that will set out, subject to this final round of consultation, set out our kind of our priorities for action, lobbying, where we want to influence change over the coming years. So thanks to everybody who has already been in contact with us to date and had an input into that process. The second piece of information, there's only two, so the second piece of information that I was going to relay today was just a bit of news more generally about the housing sector and government changes. Some of you might have seen that the Prime Minister had a reshuffle of various things, and further details have now been released in a news release that I received yesterday, so relatively hot off the press, just confirming some of the details about changes to the department in government that's responsible for housing specific matters. Now, most of you have probably got familiar with the term, the acronym, which housing loves acronyms, doesn't it? The acronym MHCLG, and Ministry for Housing, Communities and Local Government. Well, we're all going to have to forget that now because they've scrapped that name, and the new name is the very affectionately titled Department for Levelling Up Housing and Communities. So DLUHC. I haven't heard any kind of variations on the names for that, the LUHC department or anything yet. So we'll see what that looks. So DLUHC is the new one. It's going to be headed up by the Secretary of State, Michael Gove. So probably a very familiar face to everybody. Robert Jenrick has been moved on. And they have also confirmed the details of the people who will be sitting beneath Michael Gove within that department. And there's not been a lot of change, so that's really good. We've been told that there's a new Minister of State called Kemi Badenoch MP and Neil O'Brien MP, who's been appointed Parliamentary Under Secretary of State. But they've also then reappointed, so good news to get some continuity at least, reappointed to the department Christopher Pincher, MP, and Lord Stephen Greenhalgh, and then the Parliamentary Under-Secretary of State has stayed the same, and that's Eddie Hughes MP. So the other little bit of news is that they've also confirmed that the former Bank of England chief economist, a chap called Andy Haldane, has been appointed as the head of the Levelling Up Task Force. So we'll see what that means. Further changes, and it'll be interesting to see how those develop. I'm now going to hand over to our guest speakers today. As I said, it's Dave Simmons and John Goodwin from the Housing Ombudsman Service, and I'm really looking forward to receiving this presentation and the subsequent discussions that take place. So over to you, Dave and John, and I'm going to mute myself now. So thank you very much.
Thanks, Darren. Morning, folks. Thanks for joining us. Just bear with me a minute. I'll just bring the slides up. Oh, just a sec. It's very slow. Okay, can you all see that okay? Thumbs up. Can you see that, John?
Yeah, that's fine.
Brilliant. All right. Well, look, thanks for inviting us along this morning, folks. We're going to talk about the Housing Ombudsman Service, which is obviously where John and I are from. Some of you may be familiar with us, some of you not so familiar with us, but we're really going to give you an overview really of what we do, what we're about, and what's going on at the moment, as well as how we're performing against the aspirations of the white paper. So we've got an hour, I think. We've got until 12:15. We're here for you. I think John and I are going to be speaking for around 35 minutes. So we will have time for questions and answers at the end. But as we go through, if any questions to mind, feel free to pop them into the chat, or put your virtual hand up, or when we finish between slides, we'll stop for questions anyway. And you can just enable your microphone and ask us directly. So I'll just, before I go through the agenda, I'll just introduce myself. I'm Dave Simmons. I'm Sector Development Lead at the Housing Ombudsman Service. I've been at the service for around 14 years now. So I've held a variety of roles. For the most part, I've worked as an adjudicator, but for several years now, I've worked as Sector Development Lead. And in this role, I'm responsible for promoting best practice in complaints handling and sharing insight from complaints. And a lot of that work I do through the writing and delivery of workshops and webinars such as this. And I also do a lot of work around putting together learning tools for our website. And John and I are going to talk through some of the things that we're doing at the Ombudsman to promote learning at the moment. So that's me. Outside of my time with the Ombudsman Service, I'm also a mediator. Most of the mediations I do on a voluntary basis for a community mediation service based in Croydon. So that's me. I'm with John. I'll just pass over to you to introduce yourself, John.
Yeah, good morning, everyone. Great to see so many people. I'm John Goodwin. I've been with the Ombudsman about 10 years now. Most of that time as an adjudicator, which is one of the people who investigates complaints. But I've now got this new job title, Systemic Adjudicator, which I'll say a bit more about later. So I'll be investigating the wider problems against landlords where they're repeatedly getting things wrong, having service failures. So the more serious investigations. I also do a lot of work on sector development, particularly with Dave, working with landlords and residents to try and improve complaint handling and dispute resolution. Previously, I did work for the Audit Commission as a housing inspector, worked at Shelter and worked at the London Borough of Camden. So I've been in housing quite a long time. Looking forward to speaking to you today because lots been happening. The last year, we've been on the opposite of furlough, I think, Dave and I. We've never been busier. So we're lucky, really, to have been so busy doing lots of work, lots happening at the Ombudsman, which we're going to tell you about. So Dave's going to take you through the agenda of what we're going to cover.
Thanks, John. So just briefly, and this is what we're going to cover today. I'm going to just talk about the background to the Ombudsman Service, just to give us a little bit of context. And I'm going to talk you through some stats about the kinds of complaints that we receive at the Ombudsman. Then I'm just going to give a brief overview of the Complaint Handling Code, which we introduced to the sector over a year ago now, which I'm sure you will have heard of. And then John is going to talk about the new scheme that accompanied that code and the new powers that we have under that new scheme. Then John's going to run through how we're currently performing against the new expectations, the aspirations of the social housing white paper. Then I'm going to just talk about briefly the residents panel that we recently set up, which some of you may be on. Then John and I are going to, between us, we're going to talk about the new Centre of Learning, what's going on at the Ombudsman Service in terms of promoting learning from complaints. We've got a lot of things going on there, which hopefully you'll find of interest. Then John is going to round things up with the final slide, just talking about a couple of other little projects we've got going on at the Ombudsman Service. So that's the order of play. As I said, we will be stopping for questions, but if you want to put anything into the chat function, then please feel free to do that, and we'll pick those up and answer those as and when we come to pause. So first of all then, the Ombudsman Service. So we've got a membership of just under 2,500 landlords, as it says there. So it's mandatory for all housing associations and all local authorities to be members of our scheme. That includes ALMOs and almshouses as well. So we do currently have 71 private voluntary member landlords, but the nature of that, it is voluntary. So there's no obligation for private landlords to be members of our scheme, and we have found sometimes that they tend to drop out when we make findings against them. So that number of private voluntary landlords does fluctuate, but we've obviously got potential there to expand further into the private rented sector. And another statistic there you might be interested in, our reach is quite, it's quite big. It's nearly 5 million households, as it says there. So we have a scheme at the Ombudsman which sets out what we can and can't do. It sets out the limits of our authority, says what complaints we can look at, what we can't look at, what kind of findings we can make. So there are mandatory grounds under the scheme which must be met before we can consider a complaint. Firstly, the complaint must be about a member landlord. And secondly, it must have been raised by somebody who has a license to occupy, tenancy agreement, lease, or other arrangement to occupy premises owned or managed by a member landlord. If those two grounds aren't met, those mandatory grounds, then we simply can't look at the case. It's not within our jurisdiction. There are 18 discretionary grounds under the scheme as well, under which we may decide not to look at a case. I won't run through all of them, but probably the most common reasons we may decide not to look at a complaint is firstly down to timeframes. So we expect complaints to be raised with landlords within 6 months of the matters in question occurring. We also expect residents to bring complaints to the Ombudsman Service within 12 months of completing a landlord's internal complaints procedure. As I said, we do have discretion on that. If there are good reasons as to why those complaints weren't raised or brought to us sooner, then we may decide to look at them. But generally speaking, we won't look at complaints that haven't been raised with landlords or brought to our service within those timeframes. Another common reason we may decide not to look at a case is because it's been subject to legal proceedings, where the resident will have or has had the opportunity to put forward the subject matter of their complaint in a court of law. And probably the third biggest reason as to why we may decide not to look at a case is because it falls properly within the jurisdiction of another regulator or dispute resolution body, where we think it's fairer, quicker, more appropriate for that particular dispute to be dealt with elsewhere. So like I say, they're the three most common reasons. We've got 18, they're written into the scheme, which you can find on our website if you are interested in having a further look. So as it says here, our powers then, they're statutory and our decisions are binding. So we often get asked by residents, what if the landlord doesn't comply with your orders? Well, the fact is we have reserved powers under the scheme to take landlords to court to get our orders enforced in the event that they don't comply with them. We won't close a case until we see evidence that a landlord has complied with any orders that we've made. So we have these reserved powers there. I've been at the Ombudsman Service for around 14 years. We've never had a situation where we've had to resort to those measures, but those powers are there in the event that we should need them. And we differ from other ombudsman services because we have a dual role. We have that traditional role of investigating complaints, making orders, recommendations to resolve disputes, but we have this secondary role of enabling the effective dispute resolution. So what we're trying to do here is to equip residents and landlords to be able to resolve disputes between themselves without having that reliance upon us. And some of the ways that we're trying to do that, John and I get into detail later on in the slides. So we see our role in housing as being much broader than just a dispute resolution service, and that's reflected in our vision, which, as it says there, is to improve lives and housing services. And we aim to do that by sharing the knowledge and insight that we get from complaints to help shape and influence and improve the services that are being delivered in the housing sector. So to fulfill that dual role and achieve that vision, we need to be a very proactive ombudsman service, which we are, and we actively promote learning from complaints. And we're making a concerted effort now to share the insight and knowledge that we get from complaints with the sector, with the view to raising standards. So some of the things, like I said earlier, that we're doing to promote that learning, John and I are going to run through in some of the final slides. So we often get asked about our funding. Where does our funding come from? Well, landlords pay a subscription fee, and that is currently £2.16 per unit of housing that they have. That's where we get our funding from. So interestingly, that subscription rate, that did remain at about £1, between about £1.15, £1.20, I think it was, John, for years. You know, it would go up by about 5 pence a year. But Rick came in, Rick Blakeway, the new ombudsman, and it leapt up by nearly £1 there. So that obviously means that our resources have increased and our number of staff have increased. And during lockdown, we have actually doubled in size. So we were normally hovering around the 60, 70 people mark. I don't know the exact figure, but we are now around 120 members of staff. We've literally doubled in size over the last year. So we've got far more resources in place, more caseworkers. We've set up new departments. John and I are part of a new department, the Quality Engagement and Development Department, which is tasked with sector engagement, you know, workshops such as this, and also looking at systemic issues. John's part of a new systemic investigation function, which he's going to talk about later on. So that's just a brief background to the Ombudsman Service there. I'll just move on to stats. This is the kind of things that people are complaining about. You're probably not surprised at all to see responsive repairs as being the biggest proportion of complaints that we receive. That has consistently been that way in the decade plus I've been at the Ombudsman Service. Responsive repair complaints hover at around 40%. It's by far the biggest category of complaints that we receive. Second, and it's always been second to repairs, is antisocial behaviour. It's written there as tenants behaviour, but that just means antisocial behaviour complaints. That's the second biggest category, and always in third place as well as complaint handling. So those are the big three categories of complaints that we receive at the Ombudsman. So the new complaint handling code then, so we introduced this to the sector last July. That's when it was published. So it's over a year old now, and I'm sure a lot of you have heard of that, but I'll just give you a brief overview of where the concept for the complaint handling code came from. This really stems from the Green Paper, the top to bottom review of social housing that took place following those tragic events at Grenfell. So that was 5 chapters long. One chapter was dedicated entirely to complaints handling, and within that chapter it highlighted some of the concerns that residents had expressed when it came to raising a complaint. What were the barriers to successfully being able to raise an issue and get it resolved? And some of those are listed here. Residents said they found the complaints procedure difficult to access. There weren't enough access routes to enable residents to actually raise a complaint. And they're having to go to extraordinary lengths to actually get a complaint registered, actually be able to speak to somebody. They found complaints procedures overly complicated as well. They differed from one landlord to the other. There were differing timeframes for responding, as well as a different number of stages. There were 1-stage processes and sometimes up to 4-stage processes. So there was a lack of consistency there. There was a lack of clarity. They found complaints procedures overly complicated is another thing that residents said. Didn't understand how to get from one stage to the next, and that includes how to get onto a third party, an independent body such as the Ombudsman Service. But really the key point that came out of this was that it was just taking too long. Residents felt it was simply taking too long to get to the point at which they raise a complaint, to get to the point where they got some kind of final solution, some kind of justice. And residents felt they were unable to hold their landlords to account for these reasons. So it's important to draw on our experience at the Ombudsman as well when we're talking about where the concept for a complaint handling code came from. So at the Ombudsman, we also experienced delays in landlords engaging with residents, unreasonably delaying and responding to them, or on occasion not responding to them at all. We also found that landlords were unreasonably declining to accept or escalate complaints, not providing a fair, valid reason for taking that course of action. And we also found that there were delays in landlords engaging with us, most notably when it comes to providing us with that information we need to undertake a formal investigation. Sometimes that information will be unreasonably delayed in being provided, but sometimes that would not be provided at all. So our response to this, our response to the Green Paper, was to introduce a complaint handling code for the sector. And it's important to point out that we came up with the code in consultation with the sector, and we were conscious that this consultation group should have an equal representation of both residents and landlords. So as you can see there were some very much resident-orientated organisations on that external working group, including TAROE and TPAS as well. And actually Michael Geller from TAROE, he was part of that working group. So there are also some of the more neutral partners in housing, such as the Chartered Institute of Housing and Housemark present on that group, as well as some senior members of staff from a number of different landlords. So it was a good mixture there. And we put that external working group together. We came up with a concept of what the code should look like, what should be included, what's already out there in the sector. We considered that, put that into the mix. And we then came up with a draft internally, which we put back out to that external working group at the end of last June. And we made a few final tweaks to the code, and the final version was published on the 7th of July. So that gives you a bit of idea about the background, where the concept came from, and the process that we went through in coming up with the complaint handling code. So the idea of the code, as it says there, is to introduce a high-level framework to support effective complaint handling. It was really, the idea was to address directly those issues raised by residents as highlighted in the Green Paper, and the intention was not to catch anybody out, far from it. It was simply to make things better for everybody. This isn't just a guide for landlords, it's also a guide for residents, so they know how to go about raising a complaint and what they can expect from their landlord's internal complaints procedure. So the code is quite general in terms of the principles that it promotes, but it is prescriptive where we thought it mattered the most. And this is when it comes down to the number of stages and the timeframes for responding. These are areas where we thought greater consistency was needed as to how complaints were managed across the housing sector. So the code promotes a two-stage internal complaints procedure. 1 stage and 4 stage is no longer considered acceptable under the code. There is provision for a 3rd stage in instances where landlords think that is necessary. For example, the code heavily promotes resident involvement. So if a landlord has a stage 3 with a resident panel on, that could be considered a good reason to have a stage 3. But generally speaking, we wanted to see 2 stages adopted across the housing sector. It was also prescriptive when it came to timeframes. We asked for a 10-day target response time at stage 1 and 20 days at stage 2. But there is discretion to extend those timeframes by 10 days at each stage and beyond that in instances where landlords need more time. Because what we didn't want to do was encourage landlords to hit these target response times at the expense of actually dealing with the complaint properly. So we hope we've struck the right balance there by encouraging landlords to give complaints more priority, deal with them more quickly, but also enabling them more time as and when that is needed. Because I'm sure as residents, you would rather a landlord took a little bit longer to deal with a complaint and give you a proper quality response that actually addresses the issues to hand, rather than throw out a response within those target response times at the expense of dealing with a complaint properly. So that was a balance we were trying to reach there. So the code also promotes a good culture. A good culture, as far as we're concerned, is one that involves residents, either at a scrutiny level, a consultation in the formulation of policies and procedures, or as part of the dispute resolution process itself. It's one that's open and accountable when it comes to complaints, as opposed to being partial and defensive. And most certainly, a good complaint handling culture is one that seeks to learn from complaints. We encourage landlords to use complaints as a source of intel, to capture that learning, to nip in the bud any systemic issues that might be coming up, and to put in place positive changes in service. So that is a requirement of the code now. It's something we've always promoted, but now landlords need to demonstrate their learning from complaints as widely as possible with a specific requirement that information is included in their annual reports. So moving on, the code has 6 sections. It has a universal definition of a complaint, which we ask landlords to adopt. It also talks about access. It's a requirement for landlords to provide a variety of routes through which residents can raise formal complaints. It should be as easy as possible. We mean email, telephone, in person, online, letter. There should be a variety of access routes. Having one access route, for example, an online portal, does not meet the requirements of the code. It also talks about procedure and timeliness, fairness. Part of fairness is making sure that residents have had the opportunity to put forward their side of the argument before a decision is reached. Also talks about putting things right. Section really does focus on remedies, what an effective remedy should look like, what should be considered, and what should be included. And there's also a section that covers learning and improvement. That comes with some of those new requirements about learning that I talked about a moment ago. So it differs from other best practice, as it says there. This is important. There's been a lot of best practice floating around in the sector for a long time, but the code is different. The landlords are expected to meet the expectations set out in the complaint handling code. It's actually a requirement. And the code also came with it a requirement for landlords to self-assess. This was an opportunity for landlords to gauge how they were currently performing against the new expectations set out in the code, what changes they needed to make sure their complaint handling falls in line. So we asked landlords to undertake that self-assessment, run it by their governing body, and publish the findings by the 31st of December, just gone. We put a backstop in place of the end of March this year for landlords to make any final changes and alterations to their complaint handling so that it aligned with the code. That's what we asked landlords to do. We are starting to pick up now, John and I in our roles, some landlords who haven't completed that self-assessment. They didn't publish it, they didn't run it by their governing body. So we are taking that up with those landlords and advising that actually we've got new powers to issue a complaint handling failure order, which John is going to talk about shortly, in the event that they don't comply. So we've started to set deadlines for landlords that haven't done that. So I think that's the end of my side. I'm going to pass over to John now, who's going to talk about the new scheme.
Thanks, Dave. Yeah, just before I do, shall I pick up on, there's been a few questions in the chat, so I'll just pick up on those now, and some of them we'll come back to later. But Mark was asking whether Clarion were members of the scheme, and as Darren says, they are, because all housing associations, all registered providers of housing in England must be members of the Ombudsman scheme. Clarion currently are the largest. They've got the most units of accommodation anywhere in the country. I think they're one of the largest, or the largest in Europe as well. So in answer to your question, Mark, and I think Alan's as well, about landlords such as that have been featured in recent TV programs. There's ITV, the ITV have been running a series of documentaries about poor conditions in housing, particularly damp properties. And there's been some other stories as well. The one about surviving squalor a couple of weeks ago. In terms of our role there, we obviously only can investigate complaints about those conditions if people bring complaints to us. So we do very much investigate complaints, individual complaints, make orders, etc. But one of our concerns, we'll talk more about this later, is that some of those issues, there was a programme at Croydon, lots of damp in blocks of flats, and we found that we'd had very few complaints from those residents. So those residents were going to the media, or they were going to lawyers, but they weren't using the Ombudsman. So in response to that, that's why we're trying to improve our reach, our publicity, our accessibility. And I'll say more, we've got a particular project I'll speak about later. But we've also done a call for evidence about damp and mould in social housing. We've collected that evidence, and we're going to be publishing a report in October, so followed by a series of webinars. So again, we'll say a bit more about that later. So I'll move on for now, but there'll be more. Sorry, yeah.
Oh, John, no, I was just wondering if are you going to go on and say a little bit about some of the barriers as well to to raising a complaint, because obviously you deal with individual complaints, not kind of systemic issues, but it's only once the residents have exhausted the landlord's complaint service, and there have been, certainly to date, there have been a lot of barriers, and some of those barriers are going to be removed. I didn't know whether you were going to, are you going to touch upon that, or is it worthwhile just mentioning?
Yeah, I'll probably touch upon in this slide now, I think.
Okay,
yes,
brilliant, thank you.
Okay. So yes, because that really comes under the changes to the Housing Ombudsman scheme, which I was going to cover here. So Dave mentioned earlier that we've got a Housing Ombudsman scheme. It's our overarching document that sets out what we do, how we do it, etc. And we updated that quite significantly in September, so we got a new version. So fundamentally, the scheme has always been there. If you're a social landlord, if you're one of those 2,300 social landlords in England, we only cover England, you must be a member. And the basics of the scheme are that if you're a member, you must have a complaints procedure. And as Darren just said, if you're a resident, it doesn't matter what sort of resident, you can be a leaseholder, tenant, licensee, you have a right to go through that complaints procedure. If you're not happy with the final response from the landlord, you can bring that complaint to us. So, and then we would investigate it. So that process is still the same, but there are going to be some changes, which I'm going to talk about now, which slightly touch upon the point Darren was raising there. So we brought this new version out on the 1st of September. That basic process of individual complaints coming to us remains the same. We'll still investigate your complaint. If you've got a problem with a leak or antisocial behaviour, the landlord doesn't resolve it through the complaints procedure, we will investigate it. But we now have a new power to carry out what's called a systemic investigation if we think there's evidence of a systemic failing. So this could be the case where, for example, we think there's evidence of residents being affected by damp in a block. We would have to have been aware of that through residents bringing those, notifying us of those problems. But we could then carry out a wider investigation into that landlord. We might want to into the chief executive or council members if it's local authority. We might demand certain documents. We might even go in and interview staff. So we've got quite wide-ranging powers now to carry out a wider systemic investigation. That only came in really from the 1st of January. So we've got the procedures in place. We haven't carried out any of these investigations yet, but we're likely to do in the near future. And if we did find evidence of systemic failing, then as well as us publishing a report, we would refer to the regulator. And the regulator has much stronger powers than we do. We can make orders, but the regulator can make much stronger orders. Ultimately, for a housing association, it can place people on a board, can require them to, ultimately, it can require a housing association to merge with another if it thinks that there's poor governance or there's financial failings. So this is new territory, but it does give us those extra powers. So we're now expecting not just to deal with their complaints in line with the scheme, but also in line with the complaint handling code, which Dave has mentioned some of the contents of. So the code sets out those good practice guidelines, timescales, etc. And under the code, landlords are expected to make their residents fully aware of the Ombudsman. I know that was one of the questions in the chat. So they must make the residents aware they can go to the Ombudsman. There isn't anything specific about making a residents association aware, but I think that would be, we would take that as providing information broadly about the Ombudsman scheme, should be on the website, should be available to residents associations as well. And there's also a new power in the scheme to issue a new type of order. So we can now issue what are called complaint handling failure orders if there's a failure in the landlord's handling of the complaint while it's going through its own procedure. So in the past, we've had to wait until the end of our investigation to make orders. We might order that landlord pays compensation or carries out repairs or apologises, but this would be about an issue that has been raised some time ago. It might be a year or more ago. When the resident first raised it with the landlord, it's been all the way through their complaints procedure, then it's come to us. So we're looking back retrospectively, making retrospective orders. So we'll still do that, but we'll have these new orders that we can serve at the time a complaint is going through the landlord's procedure. So if a landlord is sitting on a complaint, they won't escalate it to the next stage, or they won't send a response. Within a reasonable timescale, we can issue an order saying, right, we've given you several chances to do this. You now need to do this by this date, or we'll take further action. And we issued, I think it was 33 of these orders in the first 6 months of this year. So since they came in on the 1st of January, and landlords then have to comply with them. So it's an extra string to our bow. We've got carrots and sticks. This is an extra one of the sticks. So they're the main changes to the scheme. But now I'm going to move on and go through some points on the white paper. We'll pick up some more questions after this section, but I know you're interested in the white paper, what it says about the Ombudsman Service, how we're responding to it. And I know that you've already had a presentation from the regulator, so I hope some of you were at that and you've heard what they're doing in response to the white paper. So the white paper, the Charter of Social Housing Residents, I think the title's really important because it is there for social housing residents. Came out in November 2020. Important to remember, Dave mentioned this earlier, this stems really from the Grenfell fire, which was in June 2017, a tragic fire, followed by the Green Paper, which was in 2018. And really what's happened since then is the government has taken from Grenfell and the Green Paper, it's taken the building safety issues around Grenfell, them in a particular way through legislation such as the Building Safety Bill, which is going through Parliament. There's a new Fire Safety Act as well, and there's going to be a building safety regulator. So there's a lot going on the building safety side. But then there were the issues around residents not being listened to, residents not knowing how to raise a complaint. So those issues have been dealt with in this white paper. So a lot of it applies to ourselves and to work done by the regulator. The first thing to say is these 3 points here, the white paper. We were very pleased that the white paper recognised our role and how, I think our service wasn't a particularly strong service in the past, but it's been strengthened a lot in recent years. It recognised that we'd introduced the complaint handling code, which already goes some way to making our service more transparent, but also raising those standards of complaint handling across the sector. It had already given approval for the new Housing Ombudsman scheme that came in September, with that new power for systemic failures to be investigated and those new complaint handling failure orders. And finally, it already approved extra funding, which Dave referred to earlier, which has allowed us to really change the way we work. So we've got extra staff, we've significantly reduced the time taken to make decisions, which I'll mention on the next slide. And we've got an enhanced service. So we've got areas which we didn't do before, such as offering mediation to residents, offering triage service to try and work out the best way to investigate a complaint. So there's a lot going on that we've been able to do with those additional staff. So those are the things that already happened. But on the next slide, if you can move it on, please, Dave. I don't think I have control. Thank you. On here are the ongoing targets within the white paper. So when the white paper came out, we drew up an action plan in response. And there were various issues referred to in the white paper. We set targets around those, which are on the left. And this is based on a 6-month update we did in May of how we were progressing. And some of these are been completed, others I can give you a more up-to-date update than what's on the screen, which is the May update. So first of all, we were meant to carry out investigations quicker, issue decisions more quickly. We were at 8 months to issue a decision in 2018. The aim is to get down to 4 by next March. So the latest figure there, 5.2, it was in March 2021. That's continued to fall. It's not fallen quite as quickly as we'd like, but I think we're at about 4.7, 4.8. So it's going to be a stretch to get down to 4 by next March, but that is still the aim. And if we don't achieve 4 months, it will be slightly more than that, which is still quite a long time. But Dave and I were around a few years ago when it was taking the Ombudsman often over 12 months to investigate complaints. So it is a significant improvement on that. There was reference in the white papers to us appointing an independent reviewer of complaints made against our service. So the white paper said, well, if somebody complains about our service, not about the decision, but about how we've handled their complaint, how we've dealt with them. We shouldn't just deal with that internally, which is what we used to do. We should have an independent reviewer. So that person, that's actually Adam Sampson, was appointed in March 2021. He used to be the director of shelter, and he was the legal ombudsman. So he's already produced his first reports looking at any complaints made against us and has made recommendations. We were set a target to publish landlords' performance, and we started doing that last December. We published the first set of annual performance reports. So every landlord, where we'd received a complaint against the landlord, we published a performance report. So if you had one or more complaint against the landlord, there is a report that says how many complaints there were, what the outcomes were, and how that compared to other landlords in the sector. It's on our website, so you're very welcome to go in. Anyone can go in, search by landlord or search by subject matter. And we'll be doing that annually from now onwards. It says 750 reports. That's because only 750 of the organisation had complaints made against them. So the others, a lot of them would be very small, like almshouses or co-ops. If they hadn't had a complaint made against them, we couldn't produce a report. There was a target to set up that we should set up a residents panel, and we should hold Meet the Ombudsman events. We're going to say more about that later. Dave's going to talk about the residents panel, which has now been set up on the next couple of slides. We also undertook to publish our investigation reports and our decisions, which we didn't previously do. And that has happened since March 2021. So every week now, we put on a new batch of investigation reports back to decisions made from last December onwards. So again, you can go onto the website, you can search by landlord or by subject matter and find our decisions. Read the full report, read our decision, read what orders we made, etc. The white paper said we should make more use of mediation or consider the use of mediation. We've gone some way to do that. We've set up some staff who are a mediation and triage team. But I think it's fair to say there's some way to go on that as well, because mediation as we do it at the moment is very much, it's voluntary. If both the landlord and the resident agree to try and reach an agreement, they do that, we will try and assist. What we haven't done yet, but we will do, is to try and promote independent mediation and to promote landlords, get landlords to offer mediation if possible, ideally independent mediation. So there's more to do in that area. This is a big one, the next one, that we should work more closely with the regulator and refer any systemic issues to them. So really one of the big areas of work still to do is how we work with the regulator in their new role. And their new role is going to include setting standards for tenants, for service delivery, setting benchmarks, setting key performance indicators. If they think a landlord isn't meeting those, they can carry out inspections, etc. Things that they didn't do in the past. So they're going to be much more involved in looking at landlords' day-to-day delivery. And if we pick up issues through complaints or through systemic investigations, then we would refer those cases to the regulator, who, as I say, could take further action. They've got much stronger powers than we have. So so far, we've already published a framework document, a memorandum of understanding with the regulator, and we're holding regular meetings. But there's a lot more still to do in that area. The white paper said that there would be an access to information scheme for housing association residents. So this would be very much like the right to freedom of information. The Freedom of Information Act applies to councils, but it doesn't apply to housing associations. So housing association residents are at a disadvantage. And to put that right, there will be an access to information scheme, and we are going to be the organisation that oversees that, makes sure that housing associations are providing the information that they should. So that's again quite a big development. We'll need to have a new section dealing with that. It's led by the ministry, whose name has changed since this slide was written, and it's really going to be developed over the next year. So it's not going to come into place for at least a year. We don't have an exact timescale yet. And finally, the white paper said the democratic filter would be removed. So this is the designated person process, where at the end of a complaints procedure, at the end of the landlord's complaints procedure, the resident can, if they want to, approach a councillor, an MP, or a tenable before coming to the Ombudsman. For various reasons, that has not worked. Only 7% of cases are referred to us by a designated person. Rarely does the designated person add anything to the process. Tenant panels sometimes do, but there's nothing to stop a landlord continuing to have a tenant panel. But there won't any longer be a requirement. There won't be this requirement that residents have to wait 8 weeks before they come to us unless they go to a designated person. So we're waiting, that's up to the government when they pass the building safety bill. In that bill is the removal of the democratic filter. So the next slide, please, Dave, which I think might be the last one from me. We shall see. So chapter 2 of the white paper, which is the one that mainly applies to us, just a reminder, it's called to have your complaints dealt with promptly and fairly, as well as the actions which I gave you an update on just now. There's other big issues still to come around housing complaints, etc. So it said the government will review and possibly broaden the decent home standard. So the decent home standard has been around since, I think it's about 2000 or 2001. It set a fairly basic standard that social housing should meet. And there's been lots of criticism saying that, well, actually that standard should be raised. It should cover other issues. Perhaps it should cover the energy efficiency of a property, you know, the warmth of the property, and it should cover the environment, so the outside areas, the communal areas, not just the property itself. So the government has set up a working group, which we are on, and they're looking at whether to broaden the decent home standard. Ultimately, it'll be their decision, but we're contributing to that. And you know, our view is that it should be strengthened in a number of ways. The white paper also says that government wants to provide better information for residents facing antisocial behaviour. So one of the things that came out of the green papers, the residents didn't always know who to complain to about antisocial behaviour. And if it's serious ASB, then obviously they need to have it dealt with quickly. So they need to know who deals with it. Should they go to the local authorities, ASB team, or to their landlord, or to the police? So there will be an information campaign. As far as I know, that hasn't really started yet, and it will be led by the government department. And also they want to run a wider awareness campaign about how to complain. So residents know that they have a right to complain and they know how to go about it. In Grenfell, that wasn't always the case. So residents didn't always know how to raise a complaint. There has been some work. The government did publish some leaflets and did a social media campaign on this a couple of months ago, but there's going to be further awareness raising as part of that campaign. But I think the important message is the one at the bottom, is that really we're at the starting point with the white paper for residents, landlords and us. The white paper is the starting point, not the end, because white papers usually lead to legislation. There could be legislation to come. There will be the regulator starting to set standards and inspect against those standards, and us working closely with the regulator. So a lot of the really important work is still to come. So keep an eye on our website for further updates. So I think Dave's now going to talk about the resident panel, unless, do you think we should more comments?
There's a question from Cyril actually, John, that's come up in the chat, and Cyril's asked about mixed tenure situations and do they fall under our remit? And yes, they do, Cyril. So part owners, shared owners and full leaseholders, they all fall under our scheme. So we, interestingly, we recently published a thematic report which focused on leasehold, shared ownership and new build properties, and we covered some of the things that regularly come up, that regularly cause complaints in these particular areas. But in answer to your question, yes, mixed tenure, they do fall under our jurisdiction. Sandy's got a question. Do you want to put your mic on, Sandy?
Yes. Can you hear me okay?
Yeah, Larry.
Great. About the complaints handling bit, one of the problems that keeps coming up, and it does keep coming up, is that in some of the councils, it's that complaints can't be looked at on a person if it's ASB, if it's longer than 6 months ago. And that is a core massive problem within the complaints handling part. Because what they say is anything that's over can't be used in court. So they don't look at any other evidence, whether it's historical evidence, which is the most important part. Even if there's been a history of somebody committing ASB and involving many people for over many, many years. So they won't look at that evidence. And then if it's 3 months clear, then it starts off as a brand new shiny case, which seems to have been an awful lot. So can you clarify if that is actually legislation that councils and housing associations cannot look at historical evidence on a person during an ASB case that may take well over a year in some cases, and then at the end of it close the case because the actual person who's causing the ASBs knows all they have to do is not do anything for 3 months clear, and that then starts the process all over again. And that is a core element of the problem with the complaint system.
It doesn't sound right to me, Sandy. We get a lot of issues in this area with landlords. So firstly, differentiating the difference between what's a report of antisocial behaviour and what's a complaint about how my reports of antisocial behaviour have been dealt with. So John and I did some work with a particular landlord some time ago, and it said we don't get any complaints about antisocial behaviour. And that's alarm bells, because that's the second biggest category of complaints across the sector. So one of the things we tried to do in the code when we introduced it was to say to landlords, your staff members need to be clear about the difference between a report and a complaint. And we get this issue time and time again with antisocial behaviour. So someone phoning up and saying, I've reported antisocial behaviour 6 times in the last month or in the last 4 months last year, and you've done nothing, that's a complaint. Someone reporting antisocial behaviour needs to be dealt with through the antisocial behaviour process. Now, I'm picking up here that the landlord is saying anything that's brought to our attention more than 3 months after it happened, we won't consider. Is that right?
Yes, that's right.
Okay. I mean, what I would suggest, I don't know what the landlord in question is, but if you experience difficulties raising a formal complaint with the landlord, you can always bring that to the Ombudsman, because your complaint, I'll just clear up on this as well. There's this perception that residents and landlords can't approach us until they've been through the complaints procedure. That's not the case. You can contact us at any point.
Well, can I just go back to that? Because this is just going to be generic talk, obviously. It's not pinpointing anything. But there was a case, it is a case, and it's just been closed again. But during that case, complaints are going in headed formal complaint by a number of different tenants. That's one. At one point, because this has been ongoing now for about the last 9 years, and they've had it, you know, people have had to move out, they've had to move people out. There's been so much stuff going on. And at one point, there was a CPN finally put on somebody. But from that point, the landlord didn't communicate with their tenants when for the next 4.5 months, they were sending through emails complaining of breaches of that. So they totally ignored it for 4.5 months. Those tenants were left with nothing. Okay. So now the case has gone through and it's just been closed. It never even got to the ASB team until 9 months after.
It's not come through to us, no, at the Ombudsman.
The end of the 8 weeks now from the complaint being closed is this week. So that's why I have to clarify this.
Yeah,
for those
you need to bring that to us, Sandy, and with all that evidence. This is what, I mean, that's what we'd be relying on. As long as you've got an audit trail showing this is what I reported when.
Yes.
Reply. We'll look at that.
Okay, thank you for that.
You're responding, okay. Have you been through the landlord's complaints procedure yet or not?
It's gone, well, at first it wasn't even put into a complaints procedure. There was no case numbers assigned to it until April of this year, and that's after it's been ongoing. So
I mean, it doesn't sound very good overall.
No.
So bring that to us. Just remember in future, it's important this, if you experience any problems in registering a complaint or progressing a complaint. We've got new powers now, as John explained, to issue complaint handling failure orders. We can proactively assist residents now.
I know, but this is the problem, isn't it? It's getting the information out to residents so that they
absolutely.
really understand now the complaint system as it should have been, as it should be now, and what it will be in the future, because there's been a huge difference. So thank you for clarifying.
Okay, all right. I hope we can help with that.
Dave,
Yeah.
is it just because we just focused quite a bit on ASB? Is it just quickly? I know there was another question that came in about whether you break down ASB complaints. Is it worthwhile? Just
Yeah, I mean, we do internally. We categorise complaints, so we can run off a report internally. I don't think we put that in. I don't think we separate that information publicly at the moment. Maybe that's something we can look at doing.
Great,
but we do break that down internally. Yes, we do. And we also publish, as John was saying earlier, all our determinations, and they will be separated by category. So you can have a look at some of the ASB cases we look at and what our findings are on our website.
Can I ask a question, Dave? It's
Sure,
James Temple speaking. Following on from my written question about details of ASB complaints by type, I think it would be beneficial to registered social providers to have an overview of ASB type complaints. Yeah, maybe that's something we can put out there, James. So like I say, we're trying to share as much information as we can and be as helpful as possible. So we're likely to be producing thematic reports on antisocial behaviour, given the fact that it's the second biggest area of complaints. That will be up and coming. I can tell you, actually, we've got one coming up where we look at noise. So the next thematic report we're publishing looks at damper mould. Following that, we're going to focus on noise, which is the biggest category of antisocial behaviour that we receive. Most cases are either about noise or have an element of noise to them. So we will be sharing this information more widely. So look out for that noise one. We'll be following that up with a series of webinars that John and I will be delivering as well.
I give a very quick response to Nigel's points. Can the regulator refer cases to us? Yes. And do you have memorandum of understandings with others, including regulators? So we have one with the regulator of social housing. We also have one with the local government and social care ombudsman, because we cross over with them quite a lot. I can't think of any others we have at the moment, but any organisations where we work closely like that, we would have an agreement with. That's it. I guess we better move on, because we only got.
We better. I'm conscious of time, so there's not really a huge amount to say about the panel. I think there's a couple of really interesting slides coming up, so I'll run through this relatively quickly. So we set up a resident panel. So we obviously encourage landlords to involve residents as far as possible, and we need to do the same. So this is really to try and redress the balance. We had a lot of interaction. We have daily interaction with landlords. So obviously we get a lot of feedback from landlords. We get to hear what they think, their side of things. So we want to hear from residents as well. Obviously we do interact with residents, run workshops and sessions for residents. We have done in the past, but we wanted to make that a more regular and impactful fixture as well. So we set up a panel of 600 residents. We initially were only going to have 100, but we had 600 applicants. What we decided to do is invite them all to be on the panel, and we hold separate meetings. We hold them in manageable groups of 100 at a time. So we first started to hold meetings in April 21, as it says there. These are all online at present. Most of the stuff we're doing, which is about everything we're doing, is still virtual. So we meet these groups of residents virtually. We hold special interest meetings, and we're inviting residents to give us feedback, most notably on our business plan. And we invite that both in these sessions and through surveys and questionnaires. And this really is to make sure residents have some input into how our business moves forward. And we want to get residents' views on some of our ideas, some of our concepts. One of the recent residents panels that I attended, actually, we looked at accessibility to the Ombudsman. Well, what kind of things were deterring people from accessing the Ombudsman Service? And it's quite interesting, some of the stuff that came up. Still got some work to do on our general perception. I think people have got a perception of us that we're sort of monsters in suits sometimes, which I hope you agree we're not, but that's still, you know, we've got to get over that barrier, that perception that we're not welcoming at the Ombudsman Service. Other things are people are deterred from online, using us online because they're not tech savvy as well. So we've got to make sure we've got a variety of access routes to get people in as well. But we've got a lot to do. What really stands out for me is that we have a lot to do at the Ombudsman Service in terms of promoting us and what we do, what we're about. I think there's still some concerns out there that we're not impartial as well. So yeah, we've got a lot of work to do on that, and it's really helpful to get the views on residents for some of those things. So that's really what the resident panel is about. And moving on, just show you, we've got the these pie charts just to show you what the makeup of the resident panel is in terms of age, and whether or not they're local authority representatives or housing associations. As you can see, the majority of the panel is made up of housing associations. There's 19% local authorities, but that really is a reflection of the sector on a whole. There are far more housing associations out there. And there's also a breakdown of the age group. So we do find that a lot of the younger residents don't tend to participate. They're not actively involved. And John and I have found that over the years as well, because we do a lot of work with residents, a lot of workshops, and the younger residents don't tend to attend these events. So if you've got any suggestions as to how we might entice them along, then we'll be pleased to hear from you. Okay, so I will just move on to the next slide before I hand over to John. He's going to finish off the last two, but we are really focusing now at the Ombudsman Service on learning from complaints and how we can help the sector develop and evolve and improve. That's really what we're about. It's what we're looking to do. So we're looking at developing a centre of learning, which we're going to put all these learning tools on. And this really is a place that all landlords and residents can go to get the information that they need, the insight and knowledge to actively help them resolve disputes and improve services in the sector. So these are some of the things we do. We deliver training. Most of this is done by John and myself, and we do in-house training for landlords, as well as in partnership with other organisations such as HQN and TPAS, and we do generic good complaints handling. What does that look like? But we also focus down on some specialist areas, such as complaints about antisocial behaviour, managing unreasonable persistent behaviours, complaints about repairs. We look at remedies, we look at effective letter writing, what should be included in that. So we cover a wide range of subject areas with this training that we deliver. And that used to be in person, but at the moment, again, it is still online, like most of the stuff that we do. But that does come with a lot of benefits. Our reach now is huge. So rather than John and I taking 2 days out and having to stay in a hotel, we can literally sit where we are at the moment and reach the whole country. So there's a lot of benefits that have come from this for us. So our website, we've got a lot on there already. We've got a lot of case studies. We've got fact sheets. We've got policy checklists as well, what should be included in particular policies such as complaints, compensation policies. We've got videos on there as well for residents as well as landlords about how to go about raising a complaint. We've got compensation guidance that you can have a look at as well. We've got response templates letter as well. I should point out on the training front, we also deliver training for residents. It's important to point that out, and currently running a series of workshops in partnership with TPAS. I've called it a masterclass in complaints handling, so I hope it lives up to its billing. But if any of you were interested in coming along, we're in the process of running a series of workshops with TPAS, which you can sign up to for free as well. So on our website as well, we've also started issuing thematic reports. So we're doing this on a quarterly basis. We've issued thematic reports in the past, which focus down on complaints about repairs. As I said earlier, we also issued one which looks at new build shared ownership and leasehold disputes. Before our most recent one, we looked specifically at complaints about heating and hot water before we issued our most recent report, which looks at cladding. And John and I are in the process of finishing up some of the final webinars on that. The next one is going to look at damp and mold. After that, we're going to be looking at noise. These come out on a quarterly basis. We run webinars on the back of those, which you can sign up to for free. We've also got a quarterly e-newsletter, which you can sign up to on our website. And we issue these quarterly insight reports as well. We really share some of the learning from each quarter that we've got from complaints. And those reports include some case studies about some of the more interesting cases that we've looked at. We also publish all our findings of complaint handling failure orders, as John said, and I think this year we've issued up to 30 odd already. And we also publish our severe maladministration cases. These are the most serious cases. We don't make that finding very often. I think it was 4 or 5 findings of severe maladministration last year. It makes up about 0.25% of all the cases that we look at where we find severe maladministration. But these are exceptional circumstances where residents have been left in extremely stressful situations, may have gone for a long time without essential amenities, but these are certainly the cases where the impact is most great on the resident. So John's going to talk about podcasts in a minute, but I will say we're in the midst of recording our latest podcast. We've just written the script for that. I'm going to be recording it tomorrow, which talks about severe maladministration, and that's going to be published on our website by the end of the month. So that's our latest podcast. Okay, John, I'll hand over to you.
Yeah, so I'm conscious of time, so I'm not going to go through all of these because I think we've mentioned these already, but these all form part of our Centre of Learning on the website. You can find this information on the website and details of these events on the website. So we've already mentioned about publishing our decisions. That's on the website. We've mentioned the landlord performance reports and Meet the Ombudsman events. We've also got what I don't think we've mentioned is we're running regional forums, different regions of the country. We've run one in every one of the 7 regions. I think they're the government regions, hosted by a landlord, attended by local landlords, sorry. The Meet the Ombudsman events are for residents, the regional forums are for landlords. So we'll be running more of those. Dave already talked about the resident panel. The podcast, this is quite recent that we're putting podcasts about different issues on the website. Dave is one of the stars of the podcast, and the first one is about repairs after lockdown, which is there if you want to go and give it a listen. And there'll be more added soon. We've mentioned the annual reports on land performance. We haven't mentioned the final one there is that we have produced some guidance for governing bodies. So for boards of housing associations and for councillors, because we think it's really important to get the people at the top to sign up to good complaint handling, to be aware of what's going on in their complaints teams and to be aware of the issues that are coming out of complaints so the organisation can learn from them. So we've put some guidance on there. And then on the final slide is a couple of other things that are going on at the Ombudsman. If you can move it on, Dave, thanks. So a few other things that have been going on recently. We carried out an annual, a landlord survey, and we also actually did a resident survey quite recently. This was in July, and we've been going through the results of those to see how we can improve as a service. And those results are going to inform a review of the complaint handling codes. We're currently looking at the code. It's been for over a year now. How's it working? What's the feedback from landlords and residents? Are there areas where we need to change it as a result of that feedback or give further guidance? So that we're in the middle of that work at the moment. We'll make a decision on that later in October. So then we'll let people know what we're going to do if there's going to be any changes. And so there is what's called an accessibility project. So it's something that's came up earlier, really, when we're talking about, we don't always get complaints from blocks of flats, which might appear in a TV documentary where there's lots of damp, but people haven't brought complaints to us. Why is that? So it's partly perhaps because of a lack of awareness of our service, or perhaps we're not accessible enough. So we've set up a project. We're looking at our data. We're also trying to identify any particular groups or particular areas of housing where we're not getting complaints, where they're underrepresented. We set up an expert group, a small group of about 6 people, or we're setting it up. Applications are still open, I think until the 8th of October, who will help us to explore how we can be a more accessible service and how we can make the complaint handling code stronger in that area about accessibility. So it's easier for residents to know about us and bring complaints to us. So that's it. That was quite a run through. Sorry, there's so much talking there. We've still got 2 or 3 minutes left. So there's a couple of further questions, I think, in the chat.
That's great, John. Thank you ever so much, and Dave also. Yeah, brilliant. Couple of thoughts which came to me as we go through, in case we whilst we wait to see if there's any one or two more questions that come through the chat function. As I think we've been dealing with them as we've gone through. One, partly a statement, also a question, but I guess you might want to comment on one. You've kind of almost got a kind of competing priorities, in the sense that you want to be more accessible, you're raising awareness, and you also want to reduce your processing timescales down considerably. Have you found one of the challenges being that you've been receiving increasing numbers of complaints, which has kind of acted against your ability to be able to reduce your processing times?
Yeah,
I think we've gone up 100%, haven't we, John? I think there's quite an alarming figure attached to that, Darren. So, and that is across the sector, every landlord we speak to is receiving more complaints. And I think it's difficult to pinpoint that to one thing. It could be partly due to lockdown easing, people's expectations rising, as well as the introduction of the complaint handling code, which talks about accessibility and actively promotes complaints and raising complaints. So that's happening across the board, and absolutely that is right, Dan. That is that increasing amount of correspondence that we're receiving is making it more difficult for us to meet our aims of providing these quicker response times, this faster service. So we've just got to be smarter in the way that we work. And as John was saying, we have come up with new ways of working, more mediation. We've got this new triage system. So our dispute resolution has changed. We've tried to be more adaptable and find different ways of certainly focusing on resolving complaints earlier, as opposed to undertaking formal investigations. So when I first got to the Ombudsman, our process was focused on the formal investigations, looking at things retrospectively, getting it through the complaints procedure so we could undertake a desk-based investigation. It's now more focused on enabling residents and landlords to resolve disputes between themselves. So that's really what we've got to put more focus on.
The second one I was going to say, I'm going to link in with what Sandy's just put through about, I guess it's an accessibility issue, isn't it? Is if you kind of funnel through a particular route, something which we're experiencing where we're helping to support tenants and tenant groups is kind of another step removed from this, but it's also really about accessibility. Sometimes you find that the landlords find it a lot easier to kind of outsource the management of complaints to a third-party contractor at this, alongside the delivery. So they say, oh, if you're delivering our, say, responsive repair service, or even more so, it might be kind of major repair programs, then you're also best able to kind of respond to issues when they arise from residents. So if residents raise a complaint, they do. But there's a kind of almost an intrinsic aspect to that, that if you're the contractor and you're receiving complaints, the last person you want to know that you're receiving complaints and maybe not doing a good job is the landlord, who is the body that's registered with the Housing Ombudsman Service. So they kind of, what we still do find is that they kind of go through this kind of circular motion where they kind of raise an issue and they try to put it right, or they don't try to put it right, but they never get back to the landlord to raise the issue, who would then be following your complaints handling code. Do you still find that that's something you do, and any solutions or plans in the future to kind of address that kind of frustration that residents definitely still experience? Yeah,
well, it does happen. I mean, sometimes I think it's inevitable. If a local authority has an ALMO, the ALMO will often deal with the complaints. But what we always say is, ultimately, it is the landlord that's the member of the Housing Ombudsman Scheme. It's the landlord who certainly should be making the final response to the complaint. It might be that they have a managing agent or someone helps out at an early stage, but it should be the landlord that's owning that complaint and sending the response. It does sometimes make sense for a contractor to investigate the very first stage, but if the resident's not happy with the outcome of that, that should then be going to the landlord, and the whole process should be overseen by the landlord. We do get problems around that, but we're trying to be, it's very clear in the scheme, it's the landlord who's responsible, not the third party. And we've made that clear in the code as well, I think.
Yeah, I mean,
that happens, but less than it used to, I'd say.
Yeah, I did just picking up on that, John, as well. That's the universal definition of a complaint in the code says we expect landlords to take responsibility for the complaints about the actions of third parties acting on their behalf. So that's what we expect. And we were aware of all this happening. This is one of the things we tried to address when we introduced the complaint handling code. So there is an expectation there that landlords do take an oversight and an overall responsibility for these complaints about third parties.
And I think, as Dave said earlier, that if somebody's thinking, well, I'm getting fobbed off by the contractor or the managing it, I'm not getting through to the landlord's complaints team, then call us, because although we can't investigate the complaint till it's exhausted the process, we can help with getting it through that process. That is our role. You know, we will contact the parties and say, why are you handling the complaint like this? You need to do this.
That's great, John and Dave. I think that's a very clear message. I'm aware of time. I'm also aware that Joan has asked if she can ask a question. If we take just Joan as the last question, and then we bring things to a close, if that's okay.
Don't forget your mic, Joan.
There we go. It's not really a question, it's an observation. Some people are really reluctant to complain because there is a mindset still that if I complain, then my tenure is in jeopardy.
Yeah.
And I still think that is true. So I mean, we've got to reach out to those people, and also the demographics on your pie charts about the ages of people getting involved with the resident panels, that pretty much reflects the involvement of people getting involved with housing associations anyway. It's really difficult to engage younger people.
Yeah.
And the other one is I follow a local Facebook page. I don't interact, but I watch, and that is the biggest burner of complaints happening with residents. One person says one thing, sparks it off, and before you know it, you've got 100 people jumping in. One thing leads to another, and actually I take screenshots, take them back to my housing associations, and the bad ones they look into, and invariably these people haven't even been in touch with the housing associations. They prefer to sort of do the complaining amongst each other, and so I guess we lose people there, don't we, by complaining in that way.
You're right, and as I was saying to Sandy earlier, we've got work to do. That's quite evident to us on promoting our service and what we do. And one of the standout things, I mean, I've just been sifting through the recent resident survey that we did, and what you said about concerns about repercussions is something that comes across very clearly. There are concerns about repercussions, you know, losing your property. If I raise a complaint about souring relationships with a neighbour or with the landlord. So these are all things we need to address. John and I recently, we've undertaken a review of the current complaint handling code. We've made some recommendations, and this is one of the standout things. We've got more to do to promote ourselves and also to reassure residents you're entitled to raise a complaint, and also make it clear that we want to work with landlords. Landlords should be working with us to raise standards in the sector and make sure people live in safe, decent homes as well. So we need to get these messages out there. But yes, we've got work to do. I agree with everything you've said there, Jane.
That's brilliant. Thank you, John and Dave. It's been a really informative session. I think the feedback reflects that as well, that we've had throughout today's webinar. Also, I think remains is for me to say a massive collective thank you to both Dave and John for coming along today and speaking. And we look forward to seeing everybody else. Thank you for joining, and seeing everybody else at our next webinar session as well. So, yep, thank you very much. Thanks, guys.
Thanks, everyone. Take care.